Hey, Judge, you ready?
Ready when you are.
Ready to talk of H. Collins, come on up.
Hey, good morning. Really? You are Miss Collins. Miss Collins, you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. You have been given PR bond. Are you, deputy, do you have a trash can right there? Can you have her spit out the gum? She's chewing it like it's smacking like it's. Thank you. Your case is 345 days old. We set cases for trial at 180 days. Just to give you a little perspective, you get no more PR bonds and you will get a GPS monitor on your ankle so I know where you are at all times today. You get one setting to decide what you want to do. I will appoint you a lawyer today. You will be back in 30 days. You must accept the plea bargain agreement or I will set your case for trial and there will be no more plea bargain agreements for you. You understand me?
Yes, sir.
You're also ordered not to consume alcohol or illegal drugs. You will be randomly tested if I find that you're using. You've already gotten 2 PR bonds. There are no more. If you ever miss a court date again, your bond is at 5,000. It will triple, quadruple, quintuple. Do you understand me? I'm gonna have you sign a reset. You'll get withdrawn for your bond conditions and then we'll have you take your seat in the jury box.
All right, bottom of 11, Gonzalez, come on up. Go ahead.
Good morning, Ms. Gonzalez. Ma'am, you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, ma'am.
On 7/29/2026, the PD responded to Harris County, Texas for a family disturbance. CW agent Castillo stated that he had been in a dating relationship with defendant for 6 months. CW reported defendant arrived at his residence, angrily banged on his door and confronted him about talking to other women. During the argument, CW stated defendant struck him in the face with a closed fist, causing pain, bruising, and a laceration beneath his right eye. Deputies observed the injury. CW positively identified through driver's license as CW defendant positively identified. CW positively identified the defendant as the assailant using Texas driver's license photo. CW wished to pursue charges. No criminal history.
Yeah. Ms. Gonzalez, I'm going to find that there's probable cause to go forward with your case. As a condition of your bond, I'm ordering you not to consume alcohol, illegal drugs, unprescribed controlled medication. You will be randomly tested. You're ordered not to have any contact with this person, not to be in possession of any weapons. Do you understand? There is a protective order that has been issued in this case, and you need to get to know it. If you violate the protective order, they can file additional cases against you, and it just goes sideways real quick. Do you understand me? How old are you, ma'am? You're 20.
28.
You're 28 years old. What do you do for a living? Why? Everyone is having a difficult time. That means you just quit on life? Right. How are you going to support yourself? Relying on a man? How are you going to support yourself? Relying on a man?
Okay, pause. Did Judge Fleischer just call men dogs on the record? Yes, he did. And honestly, he's not wrong. Statistically, financial dependence is one of the biggest reasons victims stay in toxic cycles. But here's the legal twist. He's not just giving life advice. He's using this as a bond condition motivator. He's telling her, prove to me in 2 weeks you're self-sufficient, or I'm not cutting you any slack. Is that harsh? Absolutely. But is it effective? That's the question I want you to answer in the comments. Would this speech make you get a job?
A strong, educated, and gainful woman. Relying on a man never works well. Men are dogs. Do you understand? It is time for you to get a job, and I'm bringing you back in 2 weeks to see what you have done. If you have done nothing, it's not going to go well between us. Do you understand me? All right. I'm going to have you sign a reset. Do you mind appointing her a lawyer, please?
Yes, Judge.
Well, I'm going to have you take your seat in the jury box. 2 weeks. You understand?
Yes.
Come on.
This way. All right, Judge, next is top of 19, Needham.
Good morning, Mr. Needham.
Hello.
Sir, you're charged with driving while intoxicated, second offense. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On 7/31/2026, officer conducted a traffic stop for failure for an
Maintain a single lane.
Maintain a single lane, almost striking another vehicle in the adjacent lane. Defendant was identified as the driver. Officer observed a strong odor of alcoholic beverage, slurred speech, and red glossy eyes. Officer asked defendant where he was coming from, and defendant stated that he does not answer questions and became uncooperative. Officer asked defendant to step out and observed defendant's groin area to be soaked from possible urine, and also noticed defendant's belt to be unbuckled with an unbuttoned. Defendant refused SFSTs, DIC 24 was read. Defendant stated, I will think about it twice. Officer took that as a refusal. A search warrant was obtained and executed. As defendant was getting fingerprinted, defendant told officer, you effed up my life, and so I will F up yours. Defendant was previously convicted of a DWI on 10/17/2023.
Does he have a license to drive?
He does, yeah. It's a he does.
You sure?
I mean, that's what he's saying.
Okay. Mr. Needham, I'm going to find that there's probable cause to go forward with your case. As a condition of your bond, you were ordered not to consume alcohol, illegal drugs, or unprescribed controlled medication. You will be randomly tested for illegal drugs. If you're using, I will revoke your bond and put you in jail. Because it's a second offense, I'm now requiring you to obtain an ignition interlock for any car that you drive. It doesn't matter what the reason is. If you don't have an interlock, you're in violation of these bond conditions. I will revoke your bond and put you in jail. Do you understand?
Yes, that's right.
All right. We are going to reset your case to give you time to hire a lawyer. I send notice to DPS in Austin. Every police officer in this state will know if you're caught driving a vehicle, the vehicle doesn't have an interlock, they're going to take you to jail. Don't be crafty. Do you understand?
Yes.
All right. I'm going to have you sign a reset. We'll have you get your bond conditions. After that, you'll be free to go. Please.
All right, Judge, bottom of 31, Williams. First initial F.
You are Mr. Williams. So you're charged with unlawful carrying of a weapon. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you. Okay.
On 8/2/2026, officers conducted a stop on a vehicle in Hagerstown, Texas for littering, throwing a McDonald's cup out the window. Officers met with the driver, the co-defendant, who gave a fake name and date of birth. Officers later learned his real identity and learned the defendant was wanted for evading with a motor vehicle. The defendant was also giving the officers a fake name. Defendant was arrested for littering and having an open container. Record search of the vehicle reveals multiple drugs, but where the defendant was sitting was a backpack with a Draco FA. And at his feet was another bag of 15.9 ounce of marijuana.
Did you say where the gun was? I didn't hear it.
It was in a backpack in front of his feet.
Okay, and his.
Yes.
Okay. Mr. Williams, I'm going to find that there's probable cause to go forward with your case. As a condition of your bond, you're ordered not to have any contact with the co-defendant in this case and not to be in possession of any weapons. If you pick up a new case, if you endanger my city, I will revoke the bond and put you in jail. I will not give you any more PR bonds. You understand me? I'm going to protect my city at all costs. You endanger it, it's just really not going to go well for you. Do you mind filing no weapons and no contact with the co-defendant, please? We are going to reset your case to give you time to hire a lawyer. I'm going to have you sign a reset, then we will have you take your seat in the jury box while we get your bond conditions. Once you sign them, at that point, you'll be free to go. There are no mistakes in this life, Mr. Williams. There are choices. You either make a good choice or you make a boneheaded one. Do you understand me? I'm not going to warn you again. Go on.
Right this way. That's it for now, Judge. I'm gonna sign for you.
Okay, counsel, you ready?
Yes, Your Honor.
Come on up.
I think we have an arraignment for Mr. Juan Torres.
I'm ready. You mind bringing him up?
Which one is?
Are you or Mr. Torres? Sir, you're charged with assault bodily injury. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Officer investigated on 5/6/2022. Officer investigated an assault bodily injury. CW stated that on July 6, 2022, he and his girlfriend were at Bombshells to watch a UFC fight. CW stated that while watching the fight, they noticed the ex-boyfriend of CW's girlfriend, the defendant, and a group of his friends. CW and his girlfriend decided to leave, but the defendant stopped them as they were leaving and struck CW with a closed fist twice in the face. CW stated he fell on the floor and defendant struck him again with closed fists and began to kick him in the face and head. CW stated he felt pain and discomfort. CW to the emergency room. He stated that he obtained a concussion and several bruises. Officer observed photos of CW's bruised lips, swollen lips, and blood on the back of his head. Officer also saw text messages where defendant admitted to this assault.
Mr. Torres, I'm going to find that there's probable cause to go forward with your case. You were ordered as a condition of your bond not to have any contact with the complaining witness, not to consume alcohol or illegal drugs. I will test you. If I find that you're using, I will revoke your bond and put you in jail. You're not to go back to any bombshells whatsoever, not to have any contact. Do we have a co-defendant in this case?
No, well, no.
No. You were also ordered not to be in possession of any weapons.
Oh, there is one question.
What's it?
Please,
Do you have the cause number? Page 27, there's a co-defendant. I'm going to get you the cause number.
Yes, Judge, it's Saldana and it's already disposed.
Already? Okay. As also as a condition of your bond, you're ordered not to have any contact with the co-defendant in this case as well. Because you have a lawyer, I will waive your appearance. It is your responsibility to stay in touch with them. If they tell me they cannot get a hold of you, I will revoke your bond. There will be no more PR bonds for you, Mr. Torres. Do you understand me? All right. I'm going to have you sign a reset. You'll get with Veronica for your bond conditions, and then we'll see you soon.
Thank you.
Thanks.
Thank you, counsel.
Please.
I'm here, Mr. Ashton, Rob, of our age,
Okay.
on bond.
Tell me, where are we at?
So I did speak with the state, Your Honor. They have placed to locate, we're unable to find the complainant. They want to evaluate the case.
Okay, pick a day later this week. You guys eval it, tell me what you want to do, but you're at 190 days. It's time to decide. So pick a day later this week. It shouldn't be long for them to eval it without the witness. Okay? I'll waive the appearance as well.
Okay, thank you.
Yes, sir.
This is on Needham. He says that he wants to pay for the device because he wants to go with Fleischer, a company that reach out doesn't do compliance laws, and he wants to.
If he wants to pay for it, then he's welcome to, but they're his responsibility to make sure that we get all the data and the records. Because if they don't, then file the BVR. Okay, yes, sir.
Right, Judge, ready for CHAs?
Yeah.
Top of 5, Baldwin, come on up.
Mr. Baldwin, do you have a lawyer today?
No, sir. It's a little bit more time.
Great. We will give you more time. Your case is 36 days old, so get ready.
Yes, sir.
All right. All right. Come on.
Thank you.
This way. All right, bottom of 6, Britton,
Good morning, Mr. Britton. Do you have a lawyer today? Great. I'd like to ask for more hair. It's not going to happen. What do you do for a living? Great. So you earn a living. Okay. Great. It's time for you to provide for yourself as well. We don't just give out lawyers like it's candy on Halloween. You have to qualify, meaning federal poverty guideline. We don't give out like it's candy on Halloween. Do you understand? You pick up a case, that's on you. All the people of Harris County don't get to pay for it just because you want one. We're going to reset your case to give you time to hire a lawyer. There's a gajillion and one lawyers in Harris County. It's like finding a car. Don't go to Ferrari. Don't go to Porsche. Go to what you can afford. It's a matter of you going through either Google, the Yellow Book, whatever, and just one by one. You may need to do 20. 99% of them will put you on a payment plan if you ask. You understand? Please.
all right, Judge, next is bottom of 9, Escobar.
Mr. Escobar, do you have a lawyer today?
You know, I will have them Friday on. I didn't have the money until this probably comes in.
Great. We'll set you for Monday.
Okay,
Okay?
thank you.
Get on it, doggone it.
Right this way. All right, Judge, next is bottom of 13, Guerra. Guerra. All right, you're free to
Good
go.
morning, Mr. Guerra. Do you have a lawyer today? Your case is 117 days old. You have until Monday. You have to understand. We set cases for trial at 180 days. You are at 120 days. You understand? See you Monday. Be ready.
Top of 14, Harrison.
Did we send Mr. Harrison for a test?
That's in 50 days, Judge. He's THA today. It's not.
Mr. Harrison, do you have a lawyer today?
No, sir.
What have you done to look for a lawyer?
I have one.
It's time for you to have a lawyer. Do you understand? I'll see you. You have 30 days. At that time, be back with a lawyer.
All right, Judge, top of 16, Johnson.
You have a lawyer today, Mr. Johnson.
No, sir, I just listened to them, just so I'm not talking.
Now, send him for a drug and alcohol test today, please. Take a seat for me in the jury box.
Page 24, Ruiz.
Mr. Ruiz, do you have a lawyer today?
No, sir.
Tell me what you're doing about that.
I got a lawyer, I just got to go. Need a little bit more time to pay the initial down payment. I have them on other separate cases here.
Great. It's time. Do you understand? You have 30 days. When you come back, have the lawyer ready.
Sure.
All right, come on.
This way. All right, top of 25, Santa Banez.
Mr. Santillanes, do you have a lawyer today? Great. Just take a seat. We'll wait for them to come up.
All right, Judge. Top of 26, Stokes.
Good morning, Mr. Stokes. Do you have a lawyer today?
No,
Tell me what you're doing about that.
contacted over 10, 15 years lawyers.
Who did you contact? Okay, well, what do you do for a living?
I'm a drug dealer.
Great. So you make money.
Yes.
Great. We're going to reset your case to give you more time. No. This is not a negotiation.
Can I speak real quick? If I'm not able, because you're not even giving, this is my third time coming, telling you that I can't afford it. So
Second time coming.
third time coming.
Second time.
You know, I came in June, July, third time in August, my third time
All
coming.
right.
I called different lawyers. If I'm not able to fill out the affidavit, but need to prove the situation, because this case expires.
I don't care if it's 15 years
I
old.
understand.
You have to be at the federal poverty guideline making 15,000 a year.
Okay.
You understand? How much money do you make a month?
It all varies between three.
You know exactly how much money you make, Mr. Stokes.
Between 3,000 and 4,000.
Okay, you're not going to qualify for a court-appointed lawyer. Just because you don't want to spend the money, don't mean squat. Listen, this life is not about how much money you make. It's about how much money you spend. If you spend beyond your means, that's on you. And Harris County does.
He who represents himself has a fool for a lawyer. Judge just dropped a founding father quote in a misdemeanor arraignment. But let's break down what's really happening here. Mr. Stokes makes $4,000 a month, which means he's over the federal poverty line by a lot. So no free lawyer. The judge isn't being cruel. He's being constitutionally correct. But watch how he flips it. He demands a list of 10 lawyers Stokes has actually called. That's not just a lecture. That's a homework assignment. And that line about the more effort you put into things, the better you get?
Doesn't get to pay for it.
If I'm not able to get it, I can represent myself and just move forward.
If you want to represent yourself, you're more than welcome to do it. He who represents himself has a fool for a lawyer, as Abraham Lincoln said,
I can't
though.
afford it, I can't afford it, though.
At $4,000,
You don't understand, like, just because I have a job
Stop.
doesn't mean I can't afford it. Like, I have other expenses, like.
if you spend beyond your means,
Spend beyond.
that's on you.
I don't drink, I don't smoke, you know what I'm saying? I don't go out, I just take it as I cannot afford it, like I said. If I'm not able to give money, then I can represent myself to cases. Like I said, even though you don't care if it's 5 or 40 years old, I'm just ready to move forward from this case. I got a test on my leg, all that other stuff. Well, this case.
Mr. Stokes, let me tell you something. The kind of case that you have, look at me when I'm talking to you. It's a big sign of disrespect. You start going like this, It's a big sign of disrespect. And do you think judges like it when you do that? No, right. I'm not a child and I don't expect you to treat me like one. That's what a child does.
Yes, sir.
This case, a harassing communication can have a dire effect on your ability to
Yes, sir. I understand.
earn a living, to get federal grants, state grants. If you need any kind of substance from any place, this can affect you.
I understand.
So it's not just a drop in the bucket. Well, just let me plead guilty and just. That's not what this is about, because it can have a dire effect. Do you understand?
Yes, sir. So if I'm not able to fill out the.
I want proof. I want bank records.
Yes, sir.
I want tax returns.
Yes, sir.
Then show me
Yes, sir.
with your name on it,
Yes, sir.
and then we'll take a look to see whether you qualify.
Yes.
But if you're making $4,000 a month,
Yes, sir.
you're not going to qualify. I'm telling you now.
Yes, sir.
Do you understand?
I understand.
Okay, please. Hold on. This case is now 76 days old. You get 30 days. At that point, be ready. Do you understand? At 180 days, we set cases for trial, kicking or screaming. You understand?
Yes, to bring in information.
Please.
from my-
No, I want you to actively look. There are a gajillion and one lawyers out there that will most certainly put you on a payment plan for a couple $100s a month. They will represent you. It's a matter of you negotiating with them. 99% of lawyers, you can negotiate with them. Well, I can give you this much now, I can give you this much later. And you understand?
Yes.
That's what it's about. Don't call one or two, 15, 20, 30, but there is a lawyer for you,
Yes,
just like a car.
yes, sir. But if I'm not able to, I would like.
Why do you start out with such a bad attitude? Well, I can't do this, I can't do that, I can't do this, I can't do that.
I just don't want to come before you again, and then we have the same issue. Like I said, if I'm not able, I'm gonna do as what you said, I'm gonna get the bank records and all.
Bring me a list of at least 10 names of people, and I'm going to write everything that we're saying,
Oh,
because if not, I'm going to send you on your way again.
yes, sir.
But I want a list of at least 10 people that you've spoken to, price down. Don't come in here with someone who's charging you $30,000 or $50,000, because I know that but a reasonable price.
Correct.
And then I also want other proof as to why you can't afford a lawyer.
Yes.
Don't just bring me a bar napkin saying, well, no,
Oh,
actual proof.
oh.
Do you understand?
Actually, I proof on.
I'm not going to look at phone records. I'm not going to take your phone. I don't want to do that. I have bad eyesight as it is.
I understand. Sorry.
Bring me paper.
Yes, sir.
The more effort you put into things in life, the better you get.
Yes.
I didn't become a judge here by just, you understand?
No,
You put your heart and soul into anything, and my dumbass got up here, anybody can do anything. You understand me?
Yes.
We'll see you soon.
Thanks.
All right, Judge, page 27 and 28, Valdez.
So not only are you on bond for 2 cases, you pick up 2 new cases and you come in shorts. Get your point. Mr. Valdez, you now stand charged with evading arrest and unlawful carrying of a weapon. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. Another 4 PR bond. Come on.
Sorry, this morning I was just having such bad connection. On 8/8/2026, at approximately 1:13, officer was assigned to conduct a traffic stop on Black Chevrolet Tahoe in Harris County after observing the vehicle cross over the crosswalk line at a red light establishing the Tahoe stopped at a gas station. Immediately upon stopping, the defendant and the rear passenger exited and ran on foot. Officer caught him as he attempted to jump a fence after fleeing approximately 600 feet. Defendant pulled his hand away while fleeing. The officer maintained control, ordered him to the ground, and detained him. Officer conducted a high-risk pat down. A firearm was located in multiple pieces on his person. The firearm is a regular piece spot 9mm. A record check through NBT revealed that defendant was put out on bond for evading and as a result of 21 possession of a handgun.
So who was he? Was he the driver? Was he the passenger? Did the officers tell him to stop?
He was the driver, Judge, and there was a rear passenger. And as soon as they stopped, they got out of the car and started running.
Officers told them to stop, presumably?
Yes, Judge.
And they kept going?
Kept going, jumping the fence, trying to jump the fence.
What time of day or night was this?
It was 1:13 a.m.
Mr. Valdez, I'm going to find that there's probable cause to go forward with your case. Guess what happens now?
Did you feel that? That's the sound of zero tolerance. Mr. Valdez was out on bond for 2 cases, picks up 2 more, evading arrest with a gun, and shows up to court in shorts like it's a barbecue. Judge Fleischer just pulled the plug on all his bonds, slapped on a 7 p.m. curfew, GPS monitor, and jacked his bond to $20,000. This is what we call the consequences of playing games.
Guess what happens now, Mr. Valdez? You're going to jail. Deputy, I'm revoking all of his bonds. Absolutely not. And now you will get a curfew of 7 p.m. to 7 a.m. with a monitor on your ankle prior to your release. If I find that you have a weapon, if I find that you're using alcohol or drugs, I'm making your bond $20,000 now. You violate this again, I'm going to go bananas on all of your bonds. Do you understand me? Can you please appoint him a lawyer? 5,004 on all of them. Yeah.
GPS on all of them. GPS on all of them.
All of them, yeah,
Judge, even the ones on Friday's docket?
all of them. No better time to be efficient.
All right, you ready for the next one?
Bring it.
page 30 and 31. Williams, first initial M.
Veronica, no contact with the co-defendant, no weapons. Testing weekly if he does bond out. And I think that's it. Victoria.
Williams on page 30 and 31.
All right. Good morning, Mr. Williams. Mr. Williams, do you have a lawyer today? Okay, great. We'll give you another reset. When you come back, please have a lawyer, okay? Please.
All right, Judge, page 32, Wilson. We'll sign in just a minute.
Good morning, Mr. Wilson. Do you have a lawyer today? Tell me what you're doing about that. I get it, but you've got two open cases. You got to have a lawyer. Criminal cases are the most important thing in your life, not your mom, not your dog, not going to Schlitterbahn, because if you don't take care of this, you're looking at up to a year in jail, times 2. Do you understand? It's time for you to get a lawyer. We're going to reset your case in 30 days. Come back and please have a lawyer. Do you understand? All right. Wait a second. Hold on. Come on. We need bond conditions on homeboy. I don't think he's got any. Mr. Wilson, you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You're also charged with interference with emergency requests for assistance. Please. Yeah, I don't see bond conditions.
They bond conditions on the interference.
The AFM doesn't have anything.
Right. So if he does something, then I can't do anything on the AFN. So I need, please.
On 7/4/2026, officer was dispatched to a location in Harris County, Texas. Upon making contact, CW stated that defendant was her ex-boyfriend. CW stated she was at home when her and defendant got into a verbal altercation. CW stated she told defendant that he was a bad father and he didn't know how to be a good father, which made him upset. CW stated while arguing, she told him she was going to call the police and that since the pair had made calls previously to 911, defendant took the comment seriously and headbutted her and took her phone. CW stated she pushed defendant and tried to take her phone back, but defendant pushed her back. CW stated while in squatting position, defendant hit the CW's knee with the phone. CW stated she observed defendant about to leave, so she asked for the phone back multiple times, and defendant ignored, took the phone and left the apartment.
Okay. Mr. Wilson, you're ordered not to have any contact with this complaining witness and not to be in possession of any weapons. Do you understand? It's not a negotiation. Just don't have contact with this person. Don't have any weapons. Do you understand? I don't want to repeat myself, and I certainly don't want to have to put you in jail. I'm not asking much from you. Don't have any contact. Don't have any weapons. Don't pick up any new cases, and don't endanger my city. Do you understand me? Okay. We will have you sign the bond conditions, and after that, you'll be free to go.
When I was here last time, they gave me the same bond conditions or something different.
I don't see them signed, and that's why we want to make sure that they're signed. They got signed on only one case. So if you do something, theoretically, I can only revoke your bond on one case. And if you do something, I want to get both cases. You understand? Come on.
All right, Judge, page 22, Preston.
Is this it? Good morning, Ms. Preston. Do you have a lawyer today? Tell me what you're doing about that.
I have to get the down payment.
Okay, ma'am. We will give you time. When you come back, please have a lawyer. Okay? please.
That's it for now, Judge.
Okay.
I'm gonna get you to sign in just a minute.
Hi, you ready? Hi, please.
See you back.
Hey, thanks. How are you?
I have Mr. Rochelle on the docket, pure discovery hearing.
Hey, good morning.
Okay.
So.
Yeah, this can give it one time, sorry.
Anything you're missing?
So yes, the officer and judge are still not in. It was the one thing that was requesting the last setting.
The what?
Officer Hill, Mr. Rochelle.
Yeah, so Judge, I was explaining to council that normally some officers have like a little notepad that they use to help them write their office reports. Sometimes they take pictures of it, sometimes they don't. We did request it back in July 15th and we haven't gotten anything back. But I advise us, and it's usually just notes that they take like complainant's name or something and they put it on the officer.
So what do you want?
We're just asserting our rights to keep the.
Yeah, I mean, obviously, if he tries to come up and tries to use it after the fact, it's just not going to come in. Yeah, whatever's not in by now, it's just not going to be used.
Yes, thank you, Your Honor.
Okay, for sure.
Maybe she's.
Yes, ma'am. Thanks. Hey, you ready? Hey, good morning. How are you?
Okay, I have a trial case on that tomorrow. I see the state filed multiple payments today, so I'll just approach them today.
Have you had it continuous before?
On Johnson.
Connie Johnson is the name, Judge.
Do you have the cause number by chance?
It's 258-1569.
So it looks like it's a first motion for continuance, right?
Yes,
I believe this is our first trial set.
Yeah, okay. I'll grant it for you, but you're not going to get another one. So be ready next time.
and it was just an emergency for the main witness.
It's not a problem, but just be ready. I mean, if there's an emergency, come hell or high water, doesn't matter the next time.
Yes, Judge.
Okay, so just 30 days out, just whatever you want. I don't care. Yeah, just put the bit. Oh, is Ramona here?
No, I'm not sure.
No, I don't think Ramona's here today. Or I don't know. She's usually,
Thank you, Judge.
for sure. And then if you don't mind putting it in, I'll sign it.
Judge, I have
I'm ready when you are.
Okay. And we will, to address the fee, I'll ask you some questions, Judge.
Is it a first or is it a second?
The first.
Okay.
Yes.
I usually waive it on the first,
Oh, okay, great.
but if it's a trooper.
Yes, it's a trooper.
All right, you were Mr. Washington.
Yes.
Sir, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. You have worked out an agreement where they're offering you 3 days in jail with credit for the 1 day that you've done. You need to understand something important. You were pleading guilty to this offense and it will go on your record. What you also need to understand from now on, you're facing not only a minimum of 30 days in jail, but if you're convicted on a second offense, it's a $6,000 surcharge. And if you don't pay it, every $100 that you owe, you sit 1 day in jail. There are mistakes in life, and then there are choices. You pick up a second DWI, it's not a mistake. It's a choice. You either make a good choice or you make a bad choice. Do you understand? You only get so many proverbial slaps on the wrist before it starts getting worse. You are giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you are not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you accept this agreement, you can never change this or undo this. It's stuck like this forever. Is this what you want to do? How do you plead to the offense of driving while intoxicated? I'm going to find you guilty. I will follow the agreement, sentence you to 3 days in jail, give you credit for the 1 day that you've done. I will roll your court cost. That means that I'm right now taking away around $4,000 to $5,000 worth of fees, surcharges off. If you come back here, it's around $6,500 at least. You understand? Every time you get pulled over, officers will see that you have a prior DWI on your record. If you smell like alcohol or dope, how do you think it's going to go? Probably not very well. So for the rest of your natural born life, even if you have a sip of alcohol, I wouldn't get into a car. I have to suspend your license. I will do it for 90 days. Do not drive until you get a license, and good luck to you, sir.
Thank
Lisa
you,
the
Your
clerk.
Honor. Good seeing you.
Thanks. You too, Ms. Alphonse. Hey, Mr. Johnson, what's up?
Judge, I want to ask a couple questions on house rules and some fusion.
Okay.
Right.
Oh, hold on. I didn't know that you needed a fugitive prosecutor. Let me call them.
It's I just want to ask you a couple of questions.
Sure.
And may need that person, in a minute. So I've got, one, it's not Louisiana, I can give you a case number,
Okay, what is it?
2632-632.
On Verstigi?
Yes.
Okay.
So, this is kind of a garden variety deal. We did one with you a while back, out of Indiana, same thing, probation violation. Not a real serious case. And I just want to know house rules on how you want to handle that. Should we-
So typically what we do is I get Dave Kim over here. He is the fugitive prosecutor in the matter. He will take a look at it. He'll see what they're wanted for. He'll check whether their jurisdiction is actually going to come get them. If not, then he'll file a nollie. If they do want this person, at that point, we'll see whether he is okay with the bond or not. If not, then we'll go forward and then you just make your pitch to see whether we set a bond or not.
Okay.
I don't know because, I don't know what they're wanted for. I don't know what kind of criminal history they have. And
Probation
so,
violation, yeah.
but what was the underlying case? A murder case, so that's,
Just little drugs. Not even a lot of drugs.
yeah. So I have Charles Johnson that's about to sign on to it and wants to talk about presumably a bond. Okay. All right. Thanks, bud. Bye. He's coming. Hey, Tom.
Good morning, Your Honor.
What's up, buddy?
Judge, I've got a client on PTI, Juan Enriquez Herrera.
Okay.
And when he went last month to check in, they told him he could ask to get the removed.
He could do what?
If that he may be able to get the device removed early.
That's not up to me. That's up to the contract that you guys signed with the state. So,
Okay.
it's, I don't know. What's the cost number, Tom?
256-1848. Just put it in the chat as well.
And the question was removing inner law? They don't do that on DWI, PTIs anymore. They don't do, early.
I said, if they want to request removal of any device, you have to reach out to those in Augusta. We don't, we're not removing them.
Did you hear that?
And I did not, no.
You have to talk to Caitlin or who?
Augusta.
Agosto.
Okay.
But those are the two people that you have to talk to. I don't think here they can just, and I don't even think that the people monitoring have the authority to just remove it anyway. So talk to
Okay.
them and then just let me know.
Okay, thank you, Judge.
You got it. Take care.
Bye-bye.
Hi.
Good morning, Your Honor.
Good morning.
They're set for trial tomorrow.
Okay.
Let's talk about it. We have 2-hour anger management and dismiss offer, but that was on Friday and I haven't been able to get a hold of her on the phone.
So we'll keep it on for tomorrow.
Keep it on.
She either shows or she doesn't show. If she doesn't show, we're revoking her bond. And then we'll see.
That's where we are.
Okay.
Thanks.
Yeah. You speak English, Mr. Escobar?
Yes, I are.
You don't belong in a car. Your history sucks.
This one.
Don't drive, especially if you don't have insurance. Imagine if I take one of your most prized possessions and I break the hell out of it. How would you feel? This is the same thing with here in cars. Manslaughter, DWI, 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 FSGI, and now you have another FSGI and an evading arrest. Stop. It's just not fair. You've been here how long? Around 3 weeks now?
Yes, sir.
When a $20 Uber ride could have gotten you wherever you want to go. Don't matter where you want to go. It's a geographical oddity. Start using Uber. You're charged with evading arrest or detention. You're facing up to a year in jail and or a $4,000 fine. The agreement that you have worked out is 60 days in jail with credit for the 23 days that you have done. You are giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you are not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. You are not, if you evade again, you will not be with us. From now on, you're looking at a felony offense if you evade from the officers or law enforcement again. Do you understand?
Yes.
This can be used to enhance you to a felony and you're looking at years instead of days next time. How do you plead to the offense, guilty or not guilty?
Yes, Your Honor.
I'm going to find you guilty. As part of this agreement, the FSGI will be dismissed. I'm assuming, is that right?
Yes, sir.
Was there any restitution that was owed into the FSGI?
We'll be discussing the FSJ.
Was there any, I get it.
Oh, yeah.
Was there restitution?
We try to reach out to them, but right now we haven't been able to respond to them, so.
Okay.
Yeah.
All right, I'm just curious. All right, I'm going to send it you to 60 days in jail. I'll give you credit for the 23 days that you have done. The enhancement will be abandoned. Good luck to you, Mr. Escobar.
Thank you.
All right, man.
man.
Thanks, man.
Have a great
Yeah,
day.
you too.
Mike, that's my
Hey,
judge.
please. Good morning.
Good morning, how are you?
What's up?
Judge, I have an off-topic matter, whenever you're ready.
Okay, let me just finish this real quick. Okay, what's your cause number?
It is 261
Okay.
6967.
On Rodriguez.
Yes, Judge.
Okay,
So I spoke with the state. The state is willing to do a time served on the first. I know he has a warrant. There were immigration issues on this one. You would not take a time served on the first?
it's a second and it's above a 15. So, sorry. And it's in warrant status. I mean,
Understood. Would you allow him to do a walkthrough?
I don't know. I mean, he's been gone now for, I don't know.
It has been due to immigration, from my understanding of it.
Do what now?
It has been due to immigration, from my understanding.
Is he in immigration custody?
He's no longer in immigration custody. He just wants to resolve this case at this point.
Great. I'm not gonna do, he needs to come in just like everybody else, but I'm not gonna,
Understood.
yeah.
And
He
then,
can, I mean, there's a bond set. He can post a bond now, or he can come here and we'll deal with it, but
understood. I'll let him know to post it on. I'm sorry.
okay.
Thank you, Judge.
Yes, ma'am. This is Stanley Johnson, Don, right? Is this correct?
Yes.
Mr. Johnson, come up. You were on bond for DWI. You were ordered not to use. I'm now revoking your bond and you will go into custody. It goes with you. Can you please appoint him a lawyer?
Yes.
Thanks.
Let me see. I need a program. So, because. MONGHUR.
Bond or jam?
Spot.
Oof.
I was an old BFA.
Yes.
So, we're here now, with this aunt, my client did miss first day of school today, HIC. He's a senior in high school. I spoke to the chief, I told him to put a mitigation package together.
And it's 300 days, so we'll give you a week. Okay.
Exactly. So can we have a week, can I have this appearance waived or?
If it's done to what you like, yes.
Yes, there's three things that I'm gonna ask him to do between now and then. I'll present it to the chief.
Mongor, come
I
up.
have him waiting outside the room.
Okay.
You want me to come?
No, but just admonish him. If he doesn't have it done, I'm going to roll his butt day for day till he gets it done.
Understood.
1 week. And then after that, give it to you, a couple days to decide and then we'll.
Yes, sir.
Yes, sir.
Okay, for sure.
Yeah, passed.
Yeah. Oh, yeah, for sure. Who's first?
359.
Oh, let me get there. Hold on. Okay.
560. We put him on probation on June 15th.
Uh-huh.
August 1st, he picked up a felony assault family member. And the bond is set at 5,000.
15,003.
We have one that was supposed to come for a court admonishment today. So wait for a man to go to residential. He's not here yet, but I think we said we we're gonna set the bond at 20,000 in court. Okay. I'll picture that at the end of the document.
Okay. Hey. Who you here on? Thanks.
We are pushing on Jones.
Jones. Okay. No, that's wrong. Okay.
That's on this copy.
Now it's been followed.
So Judge, we reached out to the dispatch. They indicated that there is no audio 911 call because it was received directly by the deputy and was self-initiated on scene. There is a call slip which we have uploaded and provided to defense, but there is no audio.
There is no 911. So, okay. So do you have an offer on the case?
Yes, Judge, there is an offer on the case.
Great. Is your client here now or no?
No.
So we'll set you off a week because you're at 171 days. Let your client know that they can be here at the next setting, okay? To accept or reject. Okay? All right.
Yeah.
Got it. Mr. Abdullah, you're charged with 3 cases. You're charged with 2 counts of theft.
Wait, did he just compare a grown man with 3 DWIs to his 4-year-old son? And it's oddly brilliant. Mr. Alvarado had 3 DWIs in 2 years. The judge already bent over backward to amend his work schedule, and the guy still can't make curfew. Judge Fleischer is basically saying, I've been patient. I've been flexible.
And 1 failure to ID. The agreement that you have worked out is they're going to dismiss 2 of them. Is that correct? Shaw? In exchange for your plea on 1 of the theft cases. What you're doing is you're entering into a deferred adjudication, which is a type of probation that if you complete successfully, you do not end up with a conviction on your record. It's hard enough growing up as a Black man in today's society. It really is. I could never put myself in your shoes. All I know is that when you start picking up theft cases, all you do is you make your life so much more difficult. No one hires thieves. Do you understand?
Yes, sir.
Life is hard enough as it is, and all you're doing is you're continually shooting yourself in the foot and becoming a statistic. You will be tested for alcohol. You will be tested for dope. You test positive, guess what happens? You give up nearly every right known to man entering into this deferred. And if you violate any of the conditions, no matter how minute you may think it is, you are looking at 180 days in jail. And I have no problems putting you in jail for up to that amount of time. Do you understand me? If that's what it's going to take to learn a lesson, then that's what it's going to take. You are giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you are not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. This is a done deal today. You either complete it successfully or you end up getting revoked and you're looking at 180 days in jail. A lot of this life is who you hang out with. I don't give a rat's behind what your excuse is. You either do well or you do poorly. For you to complete this successfully, there is no drugs, no illegal drugs, including marijuana or anything that has THC in it. And I'm testing you in 2 weeks. You test positive. Do you understand me? You must do a TRAS. This is an evaluation to see what other conditions you need. If they assess other conditions, you must fulfill them. You must do a thinking for a change, the long one, please. 30 hours of community service. No contact with target. Who is the other?
It's Johnson.
Sure. Do they own a store? Is it in the Galleria?
It's a person that was at school. He's lost their home.
God, no contact with the other complaining witness in this case as well. How do you plead to this offense? Guilty or not guilty? I'm not going to find you guilty now. Mr. Abdullah, I promise you, you either do this well or you do this poorly. All that depends on you. What are you doing with yourself these days?
I did graduate. I'm going to start college in a couple of days. Just got into AI.
You might as well just quit. Every time someone looks you up, you know what they're going to see? Theft, failure to ID. When your name comes up against another candidate with similar experience, with 0 on their background, who are they going to choose?
Aren't you excited?
You're young. People in the workforce understand that young is dumb sometimes and they make mistakes. However, after time passes, 10, 15 years, if you don't get out of trouble, it won't negatively impact you as much because people will see, okay, well, this guy may have been stupid once. Hopefully he's going out of this. But if you continue to pick up charges, just quit because no one's going to give you the time of day. I'm telling you how it is in the real world. You understand? Perception is reality. You understand? All right. So either in 30 days, school full-time or a full-time job, provide proof of both. Don't use illegal substances. Do you understand me? Yes. All right. Good luck, sir. Thank you. Hey, what's up?
You don't stop Martin tomorrow because he's saying he has to give a speech in Austin, but obviously he has to eat up. How would we hear it from?
I don't know. I mean, if he wants to, has he had a motion for continuance before?
I don't know. He just wanted to know what position he was in line for Friday.
What do you mean for Friday?
Is it Friday that you have trouble?
No, Tuesday.
Tuesday, okay, for tomorrow, sorry.
I mean, he's probably up. I don't know. I mean, are you ready on Mark's case?
Mark Eason's case,
Barbara?
I don't believe so.
That's the one, yeah, that's the one that I just emailed. He's not first on the trial docket, Judge. It's our first motion, but to continue because one of the experts has had vacation. Is it vacation or?
Okay, so it sounds like they're gonna move for continuance.
So you're going to move because it sounds like they were too.
No, Mark's gonna go. If he has to be here, he'll be here. But if they're moving for continuance, then I'll let him know that.
On Barbara, I did file a motion for continuance about 2 weeks ago. I spoke to Mr. Thiessen. He said he was fine with it.
I get it, but have you had a continuance before?
No, that's just.
You sure?
Yeah.
What's the cause number?
It's
Mark's actually tagging in right now.
Oh.
it's been rolled.
Hey, Mark, I'm approaching on it.
Hey, Marky Mark.
Hey, man. Hey, sorry, Judge. Hey, guys. Sorry, I heard Sean and everything.
I'm here.
Don't worry about
you, man.
So-
Sorry, sir.
What's your cause number, Mark? Please.
Let me check that out real quick. Sorry.
Because it looks like the state's moving for continuance.
Yes, sir. And my cause number is 256-8896. And I said I don't have any objection because it's their first, I believe.
Okay, Judge, I'm gonna run upstairs to felony.
So what's going on upstairs as well? Are you guys set up there too or no?
No. Mm-mm. And I'd be lying to you. I think they filed that just to kind of force our hand here. And so I'm going to go win this and, well, hopefully win this and knock out the felony.
What we were told by felony, just everybody, so everybody's aware, is that if he was to plea on the DWI, they will dismiss the felony.
Exactly. So they're trying to strong arm me into taking this. So if I beat this, it takes out the felony.
Touche.
And so we're set here. They didn't file that felony till
So you know, as you know, Mark, I usually grant a first continuance, but I'm not going to do a second. So the state's moving for continuance now. They filed it first. I'll grant it. Give us, reach out to Victoria. You guys pick a day, 30, 45 days.
Yeah.
But I'm not granting another one. So
I appreciate that, Judge. And just so you see, I hope they're not buying time because felony's not pushing me to trial. And so they're not going to try and push that felony to make strong arm me into pleading.
I don't.
An email from the experts.
Okay.
I don't think there's anything nefarious going on.
Okay.
I would hope not, but you never know, right?
Good. So, yeah, no problem then. No problem. And I'll get with the office to get a new date for everybody.
Okay, my friend.
Thank you very much, guys. I appreciate the
Okay, take care.
Thank you. Okay, bye-bye.
Yeah, and if you don't mind putting that in. Tony, you need to talk?
Thanks, Cesar Ortega.
Ortega.
From Miss Vega, she's currently in the hospital.
Oh, is she?
So.
Okay, so do you know how long? She's got a case that's pretty old. That's why.
She was there, I think she was admitted Thursday.
Ortega's not an old case. Or actually, maybe Ortega is one. Hold on.
All I know is that there's a discovery issue. And I get,
Great. She needs to be here. She's the attorney record.
I understand. but-
So- I understand, right. So, huh?
Get neck surgery. So I don't know how long, she's in there since Thursday.
Okay, let's set it off a week and let's see where we're at.
Okay.
You know, she can always zoom in. So hopefully after a week, she's back bound. The other case, I don't care. You can do a regular reset, but Ortega is 190 days old. I'm not going to do long resets. You know what I mean?
That's fine.
It's time to
Yeah.
put up. Do you have an offer in the case?
Trying to pull it up, Judge, for some reason.
Is Ortega here? Ortega?
No, it was a waived appearance, Judge.
Okay, so no more waived appearances, just if you don't mind,
Stacy's not.
you know?
Well, I think it was a rip call. It was. This case that we were just talking about, I just kind of got the rundown. There's an AFM, they can't get hold of complainant. There's an FSGI that's not related to the AFM.
On Ortega?
Yes. There's the FSGI and a PCS that are attached together, two separate cases. There's three cases. On the FSGI, I haven't been able to contact the complaint on that either. And on the drug case, there's a lag. So it's not that the defense is doing anything here, it's just that, yeah.
But I need you to tell me this, not at 190 days old, so I can put their feet to the fire.
I believe that was done last Saturday. I wasn't here.
So whatever's not in, it's 190 days old. Whatever's not in is not coming in. That's it. So give you a week, knowing that whatever's out now is not coming in. You guys need to make a decision on what you want to do. So whatever's not in now, I just don't care. It's just not coming in. So make a decision on what you guys want to do. Hopefully should be pretty easy. You guys too. Eval it with all the stuff that's not going to come in. We'll come back in a week and decide.
And just to be sure, the assault family member, that's a new case. I mean, is that with for all three?
If it's 190 days old, then let me see.
The FSCI and possession of controlled substance were from February. But the AFM is.
I mean, it's 123 days old. I'm not going to do it on that. That's still relatively young.
Okay.
But on the other two, I'll exclude whatever is not in. Okay. So, but that in mind, get on it, please, whatever you're missing.
You have to investigate it. It's just the complainants are related.
There's always an excuse.
Yeah.
There's always, I mean, it's the nature of the beast. Just,
We'll find.
right. Yeah. Okay, you got it. Stace. Mr. Alvarado, come up. I have bad news for you. Is that your family over there, Mr. Ortega?
This is Alvarado.
Or I'm sorry, Mr. Alvarado? Did you just hear by yourself? You have to understand that there are no mistakes in this life. There are choices. I harp on it over and over and over. You either make a good choice or you make a bad choice. You have 2 DWIs in 2024. You pick up another DWI. So you're on bond for 2 DWIs. Normally, when I have something like that and a disposed of DWI within the same year, so literally 3 DWIs within 2 years, the bonds are relatively high. Your bonds are at 1,000 and 1,500. And I told you at the outset, when you got your second DWI, that there was no tolerance whatsoever. You came to me, said, look, Judge, I got to work. And I said, okay, fair is fair, and I don't want you to lose a job. I amended the schedule to what you asked me for. And now you're getting home beyond 10 o'clock. Unacceptable. You are going to jail today. Because if I were to do anything else, you know what would happen? It would continue, and it would continue like a little child. My son is 4, and I love him to death, but he tries to beat me down.
This is the most real moment in the entire session. Judge Fleischer isn't just reading a plea script, he's giving a survival guide to a young black man in Harris County. He says, no one hires thieves. He talks about how a record follows you forever, how perception is reality. And then he drops the most practical advice ever. A lot of this life is who you hang out with. This isn't a lecture, it's a warning from someone who's seen this story play out 1,000 times. He's not just adjudicating a theft case, he's trying to prevent a lifetime of them.
Over and over, trying to get away with as much as he can, over and over. And at some point, I have to put him over my knee so that he understands the message. Do you get the analogy? I am now putting you over my knee and you will go to jail today because you have 2 bond violations, not just 1. Do you understand?
Sure. Judge, can you at least explain like what happened?
No.
Can I speak?
Sure.
Because normally I'm with you, but in this instance, I'm not. He's come 60 times to this court in 2 months. He hasn't missed a drug test. He hasn't missed court. He's been doing everything to the letter. Now we get to the day that he's going to plead, he's going to finish. It's convenient that he's going to jail today.
There's only one reason that this is happening
No,
now.
I understand.
Right.
But
I need him to
understand. At least to figure out like why he came late or something. Was there some sort of circumstance or something?
But that's the thing is, it doesn't matter.
Okay.
It just doesn't. Stacy, you have 3 DWIs in 2 years.
No, I'm not.
You are lucky to even be out. You are lucky that someone is not dead, where you end up with a 30 to 40 year sentence, Mr. Alvarado. Do you understand the gravity of what's going on? I don't think you do, because otherwise you would be home by when curfew is.
How does that work? But yeah, I understand.
You know what the rule is. When you're on bond for 2 WIs, your life is the court, not your dog, not your grandma, not your cherry tree. Goes with you. No, sorry, I can't. Because he'll be back with the motion in 2 weeks. 10,002 on both.
Good morning, Judge.
Hi, Mr. Leonard.
I am here for an in-custody case.
Okay.
And the range last name is Black.
Okay, thank you for coming on this.
Oh, of course.
I need to bring him out though, because we need to address, he's on bond for an unlawful restraint, assault of a family member, interference, and now he's picked up a VPO. Are they all the same complaining witness?
Yes, sir. I would like to say same transaction, and we have a very revealing.
What do you mean same transaction?
Those first 3 are all.
Yeah. I get it.
Same issue.
Sure.
We have a pretty exculpatory rip call, which was the basis of my defense. Unfortunately, in this case popped up, but I plan on letting the court know about that.
Let's say 75% of the cases have. But nevertheless, you still have to abide by court orders. You can't just.
I understand. It would be to support my request for a reasonable bond.
So you tell me what you think, Ms. Shaw. I mean, let's do PC first, because I don't know anything about the VPO. I don't know how bad, dangerous, if it is at all. What, if anything, happened? I don't know.
Snippet. Officers conducted a traffic stop due to failure to signal within the 100 feet range required under the Texas Transportation Code. It was sergeant, and when they approached, they took out the passenger, and when they looked her up, they noticed that he had a protective order and they were in the same car. That's.
Okay, thanks. Good morning, Mr. Black. How's jail? Great. That makes me very happy. Court orders are there for a reason. They're not for Mr. Black to do whatever the hell he wants to do. There are court orders. And when you don't follow court orders, there are drastic consequences, as you now see. You know, we can only give people so many PR bonds before we start saying, hey, dude's just not getting it, you know? All we want are our streets safe. You're on bond for an interference, unlawful restraint, and an assault. The only thing I asked you not to do was to have contact with the complaining witness and not to have weapons. And now, what happened with Mr. Black?
On 8/6/2026, at approximately 19 hours, deputies were on a routine patrol. They assisted Sergeant who was conducting a traffic stop on Alden Bender Road, Harris County, a public roadway. Sergeant advised that the stop was based on probable cause of observing the driver failed to signal continuously for at least 100 feet before turning or changing lanes. Once the driver was identified, the stop was done, the driver was identified through Texas driver's license. The passenger was identified as Ryan Paris. It was revealed that an active magistrate order of emergency protection was issued, listing Ryan Paris as a protected person. The law explicitly prohibited defendant from going near or being in presence of Paris. The order had been issued following assault family violence, and it is from an incident from May 2026. Still active.
Got it. Do you mind filing a new MOAP on the VPO, please? I want you to hear me loud and I want you to hear me clear, Mr. Black. The Texas Constitution does not allow me, but in extremely limited circumstances, to hold someone at no bond, zero bond. This is misdemeanor court. We're not felony court where we can just hold everybody at no bond. But you are now charged with a violation of a protective order. If I put conditions on it and you violate conditions on the VPO, I can have a hearing within 3 days to hold you at zero bond. And I will do it in a heartbeat to protect everyone in my city. Do you understand me? When I mean no contact, I mean no contact at all. That means jail phone calls. That means written notes. That means smoke signals. That means use of third parties. I'm going to issue now another order for protection. You pick up another one. Now you will be looking at a 3rd-degree felony, perhaps a 3rd-degree felony, depending on if you have any other priors. Could be a 2nd degree. Could be looking at up to 10 years or up to 20 years in prison. No contact and no weapons. Do you understand?
Yes, sir.
Because of the new case, I'm now going to revoke your other bonds and I'll set them all at 5,004. I don't know if you're going to bond out. If you do, you will get a GPS monitor and you're not to go within 1,000 feet of where she lives or where she works. Do you understand these conditions?
Yes, sir.
I'm not going to have this conversation with you again. If you pick up a new case, you violate conditions, just be ready. Every phone call that is made in the detention center is recorded. Even if you use someone else's pen. You understand? I have put people in ag seg before and I'll do it again. Don't try to be crafty. Do you understand? Okay. We're going to have you sign a reset. We're going to have you sign your conditions and then we'll see what happens. Okay.
Judge, and if I may, would you be open to modifying it if you, a curfew or a GPS to at least lower the bonds on the other ones, keeping this at private?
I think that Mr. Black has just extensive criminal history. All these cases are violent cases, and yet he's still having contact. I don't think that there are any non-financial conditions that will be in place. I mean, we already had a protective order in place and he just, so
I believe
it may be due time, but now I'm not ready to just, Okay. All right, Mr. Black, good luck. Thanks.
May I do a short reset for you as well?
Yeah, whatever you want.
Damn, this could be.